Hey everyone. I appreciate the survey results and the survey suggestions that everyone made regarding what I needed to do to improve the class. And one of the things that you mentioned is trying to keep the sound down. One of the things that you mentioned is that you enjoyed the real life scenarios to better illustrate the legal principles. And so I wanted to do a series of these. I'm going to try to do each one of them fairly short, but hopefully illustrate some of the principles that are involved. It's not a replacement of the material that's already provided. It supplements and adds to it. I think in some ways, makes it a whole lot better. At least that's what I'm here for. Otherwise, if it's not adding something, then why am I doing it? Okay, I want to go ahead and share the screen to you for you and let you take a look at what is going on. Here we go. Contract law, liquidated damages, and related issues. This one's going to be on contract law and specifically related to the liquidated damages. Now, what I want to do is tell you a story about actually, this is something that I handled recently this year, represent a utilities type company. And the utilities type company services public utilities. It provides really goods and services. And it's a I would call it a small business. It's a closely held business, like most of my clients are, but it does well and deals in contracts that I think are rather large. Uh, for large companies, they would say very small companies. And the question here was with respect to one of the contracts that I recently reviewed for my client, and it revolved around this concept of liquidated damages. Now, as you know from the other material, liquidated damages are damages that are designed to approximate the actual damages. So they're to replace actual damages. They're not designed to be punishment. They're not designed to punish or be punitive for the clients. In my case, the this company that I represent sells and builds these I want to call them like housing units. They're not like residential houses. Instead, they house machinery and equipment and electrical things and generators and they're very specialized kind of builds. In this particular case, we had a contract that was for $1.5 million. Again, for my size clients, those are large contracts, but for other companies that are large, that's not so big. Well, as I was reviewing the contract for my client, I ran across a provision, and the provision stated that in the event of a delay, they had a time for performance, like a lot of contracts do. But in the event of a delay in the contract, for any reason, it didn't even have to be due to my client's fault. It could have been because of weather scenarios, or it could have been because of a shortage of materials, or anything that really could have occurred. Arguably, even the purchaser, the utility company with whom we were contracting, could have issues of their own and stop us from doing it. And arguably, any of those things would result in a penalty of $60,000 per day. I call it a penalty. It wasn't really a penalty. It was just a reduction in the price that the public utility was going to pay to my client, $60,000 a day. Now, at first glance, you might think, well, it's $1.5 million. It's $60,000 a day. That might replicate actual damages. And if it does, it's enforceable. But we need to look at, what happens. You're looking at one day. Well, what if we're delayed 3 weeks because of a shortage of materials or a particular supply or a strike in the labor force or any number of things? Well, $60,000 for one day is one thing. $60,000 for a week is $420,000, almost $500,000 a week. 3 weeks, 3+ weeks, our contract's wiped out. What do we do? Do all that work for them for free? Well, so, there's an issue that's there. Now, we were working with a standard contract that the utility company, the public utility, used with a lot of different vendors and suppliers, and some of their contracts, instead of being 1.5 million, were $150 million. And in those cases, maybe $60,000 a day makes more sense. In our case, it was disproportional. And because it was disproportional, I think that in the event that we would have, in the event that we had left it in, and fortunately we negotiated it out of the contract, so we didn't sign that. But had we signed that and had that been um, attempted to be enforced, then I think we would have argued to the court that, look, um, that's not reasonable. It doesn't approximate the actual damages, Judge. It should represent the true loss that occurred to the other side, the lost profits, lost benefit of the bargain, etc. Instead, this was a penalty. Just look how severe this was. It's designed to punish, and because of that, it should be unenforceable. And I think probably we'd win. But it's like everything else, and for purposes of your exam, the same thing. I don't care. The answer's not important. If I ask, is this punitive? Is this would this be found to be a unenforceable punitive damage or an enforceable liquidated damages? You can answer it either way and get full credit, or you can answer it either way and be wrong and get no credit. What is critical is that you analyze, wait a minute, look at this provision here. This has got to be one of those either liquidated damages or punitive damages penalty kind of provision. And what we need to look at is whether it approximates the actual damages and lost benefit of the bargain and things like that. And if you analyze that and you understand critically what issues are involved, that's what's important. It's not important that you get the right answer at the end, because I will tell you this. You have this same case and it's in front of Judge French in Jefferson County, and she'll rule one way. And then you have the same case, same facts, same law in front of Judge Bostic in Shelby County in Columbiana, and he rules a different way. You don't know, because things can do. You generally need to have some sort of idea, but what's important is understanding and being able to critically analyze the law. Okay, that's all. That's what I have for that one. I do want to ask you one more thing. Think about this for a second. We've already talked about the issue about consideration to form a contract, and we know that you have to have consideration to form a contract, but it doesn't have to be equal. Contracts don't have to be fair. Even a mere peppercorn can be sufficient consideration to support a contract. In other words, courts aren't going to weigh the sufficiency of the contract of the consideration to see if it's fair. They're just going to see if it exists. Well, how does this reconcile with that? It's not really a perfect reconciliation, is it? And this is just one of those things in the law that there is just some sort of discrepancy. It kind of makes law fun. Anyway, thanks for this one, and be looking for the next one.